Good evening, everyone. Hope everyone is doing well. I'm attorney David A. Branch from Washington, D.C. We are getting started here. We're just going to wait a minute, allow folks to get in. Come on. Oh, Sunday evening. Thank you so much for joining us. Wow. Well over 100 people joining us this evening. Okay, I'm an employment attorney in Washington, D.C. And I'm going to do a couple of things tonight. This is maybe our third or fourth webinar, but we've had a lot of things to develop over the last 2 weeks since the last webinar. It seems like it's kind of strange. This is just the first week of March, but it seems like we've already had a year's time already just in the last 5 weeks of this new administration. My plan tonight is to cover a few matters. One, I just want to give you an update on the executive orders and OPM, the guidance that we're receiving from OPM. Also, an update on court actions that are proceeding. There are at least 2 court cases that you should monitor or follow, and I'm going to give you those court cases a little later in the presentation this evening, but you definitely have to monitor these 2 court cases because they affect your rights, have the potential to affect your rights at the MSPB and how you proceed with your claims. So 2 court cases that we need to monitor. One of the cases involves the chairperson of the MSPB, Merit Systems Protection Board. Her name is Kathy Harris. She's in litigation now in the U.S. District Court, fighting to remain on the board. And the second case is of Hampton Dillinger. He's the special counsel in the Office of Special Counsel, and he was recently terminated as well by removed by the president, and he's fighting in court for his position as well. So whether these 2 individuals remain in their positions is going to greatly impact how these cases are resolved, both if you're a probationary employee and a career employee. So let me just jump right in there. This is actually a good place to start. If you are a federal employee, either a career employee or a probationary employee, and the agency takes action to remove you, you have just a couple of limited options for challenging that action. For a probationary employee, you can challenge a decision that's made to terminate you that was part of your background investigation, and the law requires that you be given notice and an opportunity to respond to anything in your background investigation that would cause the agency to terminate you. After you become an employee, there are limited circumstances where the agency can terminate you as a probationary employee. You have limited rights as well, but the agency is required to inform you of the reasons why you're being terminated. In other words, it has to be truthful and tell you why you're being terminated. Can't make a false statement about you or about your performance. And that's why we're seeing some of the litigation that's going on now. You have the right to challenge that decision before the Merit System Protection Board, but there are only limited circumstances under which you can challenge that decision. And the first is because if the decision is made because of political reasons, and that's been interpreted by the courts to mean political affiliation. So even though we think and we have reason to believe that a lot of these actions are being done for political reasons, that's not a disqualifying reason for someone to challenge their removal as a probationary employee. It actually needs to be party affiliation or affiliation with a political party. And then the second instance that you can challenge as a probationary employee is your marital status. So for most people, you don't fall in that category, but the Office of Special Counsel, which is charged with basically enforcing the Civil Service Reform Act, basically serves something like as a Office of Attorney General or prosecuting attorney. If there is some violation of the law, you can file a complaint there and allege that your agency engaged in a prohibited personnel practice or didn't follow OPM guidelines in making certain decisions as it relates to either hiring, nepotism, or termination of folks. why the first case is important, this case of Hampton Dillinger is important, is because as the Office of Special Counsel, at least 6 probationary employees came to his office and filed a complaint saying that the agency terminated them, and they raised the issue of whether this termination was in fact valid or whether it was a reduction in force. If there's a reduction in force, there's a whole different set of procedures that must be followed before you can move forward with a reduction in force. First, you have to provide 60 days notice to the workforce that you're going to conduct the reduction in force. And then you create a retention register where people are placed in different categories. And then people are listed by seniority, and often it will also include their performance, which can be a factor as well. Then if you're going to eliminate the entire department, then yes, you can terminate everyone. But if you're not going to eliminate the entire department, you have to start with people who have the least amount of tenure, and folks who are higher up can bump people and move into another position if it's available. And finally, as part of a reduction in force, there should be an offer of severance. So for a lot of the probationary employees, they were just given a notice that you're not meeting the expectations of this position. We've determined that because of your knowledge or your abilities or your skills, you're no longer a fit for the agency. And also, your performance, at least as far as we're concerned, your performance is not meeting the expectations of the agency. And these reasons are just completely false. So the employees claim that, hey, these are false reasons. I received satisfactory evaluations, which is true for most first year folks, or I haven't even received a review yet. So how can you tarnish my name and terminate me at the same time? So the Office of Special Counsel filed complaints on behalf of these employees with the Merit Systems Protection Board. And the Merit System Protection Board, which is comprised of 3 board members when it's fully functioning. 2 are appointed by one political party. The other is appointed by the other political party. So currently, as configured, the MSPB has 3 board members, a lady named Kathy Harris, as well as a gentleman named, I think his last name is Lyman, and then President Trump just appointed someone. The MSPB issued an order over the last week saying that these probationary employees essentially had a valid claim, and a stay was issued, at least temporarily, for the next 45 days to allow the Office of Special Counsel to conduct an investigation and for the case to proceed, and that the agencies had to reinstate these employees during this period of time and could not take action to remove them during this period of time. So this is a significant win for not just for these 6 employees, but if you're challenged through as a probationary employee, you can essentially cite to this as a decision by the MSPB already, by the board already, as authority to help you remain in your position. So this is not only a victory for probationary employees, it's also a victory for career employees who were impacted by any of the executive orders or actions by their agency. We were actually in the process of filing a complaint on behalf of career employees who worked at the Veterans Administration over the last week when we received this decision. And we've reached a conclusion that this is the best outcome that we could possibly see. So we had to advise our clients, we don't really want to challenge this decision. We don't want to file something in court and have a judge rule or issue an order that offers less than what's being offered in this particular case. So we decided not to go forward with filing the lawsuit because now we have the MSPB saying that you can't terminate people and claim that it's either because of their performance, either as a career employee or as a probationary employee, and mask a reduction in force. And that's what the administration is really doing. They made it clear, we want to reduce the roles of the federal workforce. And so The only thing that we have working for us to our advantage is, this issue of competence. They haven't quite figured out how to do it, but it looks like they're going to figure this out pretty soon and go forward with the reductions in force. For example, for our clients who work for the Veterans Administration, their agency issued a decision that basically said, we said we were going to terminate you, but we're rescinding that, and we're going to allow you to remain on administrative leave, and then we're going to do the reduction in force as the reduction in force should be done. So how should the reduction in force be done? If you're going to issue reduction in force, as I mentioned, you have to provide the employees 60 days notice and go through all of these different steps before you actually carry out the reduction in force. All right, so tonight I want to talk through just a couple of the executive orders on where we are and where we see this going, as well as the court actions that are in place already. And then we're going to take most of the time to just go through a review of your rights so that you understand fully. I want every federal employee to understand fully what their rights are. We have something we're going to display on the screen. You can take it as a screenshot as well. We're helping as many employees as we can. All of the employees, I would like to say that everyone has the same issue, but we're seeing the full gamut of different issues. We have people who are probationary employees who have been terminated. We have people who are career employees who have been terminated because they were either associated with a DEIA program or they even attended DEIA training. And so these folks have been terminated. And we're going to try to walk through what you should be thinking about if you fall within any of those categories. We have people who are Schedule A employees. You were hired under a disability. And so what are your rights under this disability? Talked to someone yesterday who was a Schedule A employee, and her supervisor was retaliating against her before January. And now she just received notice that she's going to be terminated. So the concern is not only does she have an issue of being placed in a reduction in force and being terminated, she also has a potential issue for retaliation or reprisal. We represent clients who are accepted service employees or administratively determined employees, employees who may not have the right to appeal to the MSPB. Now, not every federal employee can appeal to the MSPB. The MSPB is reserved essentially for career employees. And if you look at your SF50, look at, I think maybe boxes 24 and 34, but there should be a category that says whether you're a permanent or conditional employee, and that will help guide you. I talked to someone who didn't really know what their status was as an employee. So you need to know what your status is as an employee, whether you're a career employee, whether you are conditional employee, whether you are a term employee. But in any event, so there are different categories of employees. So you need to understand how this is going to affect you if there is a reduction in force. Now, I hate to be the bearer of bad news, but it's pretty clear that this administration is going to reduce the roles of federal employees and do it significantly. I think there are approximately 2.2 million federal employees. And my understanding is something like 75 to 80,000 people accepted the deferred resignation offer, the fork in the road memo that was sent. And so this administration has advised that it's going to significantly reduce the federal workforce. And so we saw this in our last webinar, that there was a recent report from the Washington Post that even before this administration came into office, there were plans in place on how they were going to carry out this reduction in force. The first thing was to take actions that were politically, let the president campaign on and that were politically favorable, and remove all DEIA or DEI related programs. President Trump did that the first night with the executive order. He could probably legally do that because the DEIA programs were implemented by President Biden in 2021. So one of the first things President Trump did was sign the executive order saying we're going to close all DEIA offices. We're going to remove all of the DEIA personnel, either place them on administrative leave, and then we're going to subject them to a reduction in force. That was the first phase. And then we're going to target probationary employees. We're going to remove probationary employees. We understand that I think there are approximately 220,000 probationary employees. So there's an effort to remove as many of those non-essential probationary employees as possible. And we see that happening every day. If you turn on the news, all of the different agencies are reporting in on how many employees they have terminated, either through the probationary employees. We saw, I guess, at the Department of Defense. We saw that at NIH. We saw that at the Department of Education. USAID was dismantled completely, and some of their services were folded into the Department of State. So we see that happening throughout these federal agencies. It's almost like these agency heads are getting, favor with the administration by reporting, hey, we are cutting 5,000, 6,000, 10,000 employees. The problem is they haven't been doing it correctly, but it looks like they're starting to learn, at least with the VA, since they recalled all these folks who were terminated because they were believed to be working on DEI work, when in fact that was not true. All right, so we're going to talk about the executive orders, talk about the court actions, and then we're going to spend some time just reviewing your rights. So let me just go down to, have my notes here. Okay. All right, so this began January 20th with the president's executive order, and then OPM began to issue guidance to the agencies beginning on January 21st. I think the first people were placed on administrative leave. The first employees were placed on administrative leave on January 22nd. We have some clients who were placed on administrative leave on January 22nd if they were in DEIA programs or DEIA offices. And a lot of these agencies did this in a way that was very sloppy, because many of these DEIA offices actually house EEO policies and were recipients of where people file EEO complaints. So it doesn't make sense to kind of tie in DEIA to EEO complaints. I mean, they're totally separate. And just DEIA, whether it's involved in some type of training or hiring or whatever, has nothing to do with EEO complaints that are required by law, where if someone needs a reasonable accommodation because of a disability, or an accommodation because they're deaf or they're hard of hearing or blind or whatever, or alleging discrimination based on race, gender, or sex, those offices are still required to function. But many times those offices were handled by the same people who were handling DEIA. But many of these agencies just came in with a sledgehammer and just crashed all of the, or smashed all of the DEIA offices. And now they're trying to figure out, what do we do with the EEO complaints and who's going to be responsible for that? All right, so let me talk through a couple of challenges. There may be 5 or 6 significant court actions. The first was a challenge to the deferred compensation offer. That was in a federal court in Massachusetts. The court temporarily granted a TRO to review the deferred compensation offer. But on February 12th, the court lifted the stay, and immediately the administration went on record as saying, we've closed the deferred compensation offer. It's no longer available to you. You can't accept it anymore, which was, a bit cruel, because the case was in litigation for 4 or 5 days, and even people who were waiting for the court's decision couldn't accept the deferred compensation offer because it was withdrawn immediately after the the court made its decision. The only bright spot here is there was a recent case in the Eastern District of Virginia, which is actually Northern Virginia. It's called the Eastern District of Virginia, but the court is in Alexandria, and it involved DEIA and people who worked in DEIA, but they were actually intelligence officers for the CIA and ODNI. And the court eventually decided that these people could be terminated, but the court ordered the agency to give them a period of time to accept a deferred compensation offer. This decision was issued this past Thursday. I think the court extended the time for people who worked in that office to accept the deferred compensation offer until this Monday. So that's one of the cases. So I'm not sure if that's going to be applied across the board, but that may be one of the outcomes, that if this matter is considered and if it's challenged in court, that the court may say, okay, because there was some confusion on the deadline, we're going to extend the period of the deadline for you to accept a deferred compensation offer. And I said this from the beginning, this administration has taken the position that it's going to significantly reduce the number of federal employees. The only thing that's going to stop this administration is the court system. And that's why these two cases that I mentioned to you, the case of the against the case filed by the chairperson of the MSPB, Kathy Harris, that's going to be an important case, and the case filed by the special counsel, Hampton Dillinger, that's going to be an important case, because if President Trump actually is able to go forward with firing the special counsel, none of the claims that we're seeing now are going to be brought before the MSPB. And if the court is successful in removing Kathy Harris, we're going to have an issue similar to what we had in the first tenure of President Trump, the first term of President Trump. In the first term of President Trump, we didn't have a quorum at the MSPB. The MSPB is composed of three board members. It needs two people to operate, to actually issue decisions. And in the first term of President Trump, we didn't have a quorum, so they couldn't issue final decisions. So what would happen? People were terminated or action was taken. They'd go to the MSPB. The first step at the MSPB is your case is assigned to an administrative judge, and a hearing is held by the administrative judge, and the administrative judge issues a decision. If the decision is favorable to you, the agency can appeal the decision. If the decision is not favorable to you, you can appeal the decision. So if you went to the MSPB and you won your case of a wrongful term, I'll just say wrongful termination, but that's not the technical word. But if you went before the MSPB and you won your case and the agency appeal, then you would not be able to get any relief if there was not a full MSPB board in place to hear your appeal. So that's why these cases are so important. One, someone prosecuting on behalf of the employees. Otherwise, you're going to have to do it yourself or get counsel. And two, the MSPB functioning as it should, adjudicating these claims and doing it quickly so that you have some relief that matters. It's not going to matter very much to you if you're terminated March 14th, and some of you are facing a termination date of March 14th, and your case is not decided by the MSPB for another 6 years, or when we get a different administration, or when the MSPB is operating as it should. I'm not trying to scare anybody. I just want to make sure that you understand fully your rights. As I was preparing my notes this afternoon, my mind just went to this place of this movie called Taken, in the scene where the father's talking to the daughter on the phone and she's hiding under a bed. And he just says to her, listen to me, you're going to be taken. And this is what you need to do to protect yourself. And I'm saying the same thing. There's a very good chance, if this administration carries out its plans, that some of you may find yourself either facing a termination notice or, things are just going to change in your place of employment. If you haven't already received a termination notice, there's a good chance that you will receive a termination notice, especially if these agencies reduce their roles. I've heard reports that the GSA plans to reduce its roles by as much as 50%. So if these agencies reduce their roles by 10% to 30 to 40%, there's a good chance that you will be selected to be part of a reduction in force. So just prepare yourself mentally, even though you've been with the agency 15 years or 20 years. I got a call a couple of days ago of someone who says, I'm just trying to get to 20 years, and that's next year. Or someone, a few years away from retirement. There's a possibility that you may find yourself being terminated. I'm not trying to obviously scare you. I just want to prepare you. All right, so that's one of the cases. The second case was the the challenge to termination of probationary employees that's pending in San Francisco. This is a great decision. The judge said, okay, it looks like these actions taken against probationary employees are illegal. But the problem is the judge basically said that his complaint was with OPM, saying OPM had no authority to, tell these agencies to go forward and terminate the probationary employees. Well, guess what? You don't work for OPM. You work for the VA, or you work for the FDA, or you work for whatever, the SEC, or whatever agency. So I'm not sure how this is going to help folks. It may correct OPM and cause them to not, issue any further guidance, but it's probably not going to help you if if you've already received a notice that you're going to be terminated. So these agencies are required to report back to the administration their progress on reducing the workforce and these plans to, I don't know, either consolidate programs or assign your duties to someone else. And I think that's what's going to happen with a lot of the people who work in EEO offices. Even though this EEO profession, it is a profession, you need to be trained on it. But we may find ourselves in a position where people are just asked to take on these additional duties of EEO duties. And that's really unfortunate, but this administration does not place a great value on EEO offices. So if you're doing that type of work, it may be that your duties will be assigned to, an administrative assistant or a program manager or program analyst or someone else who steps up to take on those responsibilities who remains employed. All right, so that's an issue with the decision that was issued by the court in San Francisco. It may be helpful, but it's still to be determined. There was a decision issued recently by a federal judge in Washington, D.C., in a case filed by labor unions challenging the discharge of their probationary members who are in a probationary status. And they basically argued, we're going to lose our union dues if all these folks are going to be terminated. And the judge said that you really don't have standing to bring your claims before this court. This is a federal labor management board issue. And if you're challenging the issue and raising that argument, you have to take your claim to the Federal Labor Management Board. And so that request for a TRO was denied. And then that takes us to the couple of points that I just mentioned before. The DEIA employees who were actually intelligence analysts but worked for intelligence agencies. And the court recently denied their request for a TRO, basically saying that the administration could go forward with the termination of these employees, but gave the employees an opportunity to resign and accept the deferred compensation offer. Really unfortunate. You have intelligence officers who are assigned to DEIA work and they were targeted and terminated. To me, that's a major issue. Folks trained in the intelligence field for their entire careers and decide to accept this assignment in DEIA offices, but then they're terminated as a result of this. But it should be a clear signal or indication to us if this administration is not concerned about people who are in DEIA positions. And I'm just adjusting my volume. I hope everyone can hear me. But if this administration is not particularly concerned about people who work for intelligence agencies, just happen to be in DEIA positions, or work for the FBI or the CIA or the ODNI, and it looks like almost everyone is expendable. So I want you to kind of think about that for a minute. If these positions aren't protected, am I doing something that's, mission critical? And that seems to be the focus of this administration on who's going to actually keep their job. Are they doing something that's mission critical? And you have to ask yourself that question. If not, then there's a possibility that my name may be one of the names put forward by my agency to be separated. All right, so I'm just going to scroll down. And the other two cases that I mentioned are the cases of the board members, the MSPB board commissioner, Kathy Harris. I've discussed that quite a bit. I just want you to get that in your memory bank and just jot it down somewhere. Kathy Harris, just monitor what happens with her case. It's pending in the U.S. District Court for the District of Columbia. The government has already appealed this decision to the D.C. Circuit Court of Appeals, and they're teeing it up for the Supreme Court. And the same is true for this Hampton Dillinger case. They've already appealed the judge's denial of their request to have the case dismissed or granted, or a summary judgment. I think summary judgment is still to come in the Dillinger case, but in the Kathy Harris case, they actually asked for summary judgment, and the judge granted summary judgment. So they're teeing this up. This is going to land on the desk of the Supreme Court. And the Supreme Court is going to have to decide whether it's going to get involved and make a decision on this case and say the president can terminate these people, or the president can't terminate these people. If the Supreme Court comes down and says that the president can terminate these people, then there's probably going to be swift movement in terms of taking action against federal employees. If the Supreme Court comes down on these issues in these two cases and says that the president can't remove these folks. Now, the law basically says that these people should not be removed except for malfeasance or some other basically wrongful behavior. The president hasn't made that argument that they've engaged in any wrongful behavior. He's just saying that as the executive, I have the right, as the president, as the chief executive, I have the right to make the decision to remove these people. So we're hopeful that the Supreme Court will follow what the Congress said in the statute and not allow these two people to be removed, because it's going to have significant it will have a significant impact on career employees and probationary employees and how the MSPB operates. So let's walk through. So those are the two cases. And so I want to take some time tonight just to walk through what are your rights as a federal employee. And we have an attachment or an exhibit that I want to post, and I want to walk through this with you so that you understand this. Now, I didn't say this at the beginning, but I always like to say this. This webinar is being done for informational purposes only. Informational purposes only. I am not counsel to you, and so you should confer, or you should consult with an employment attorney, an experienced federal government employment attorney for your particular situation. But this is just general information that I'm providing to you that should guide you when you meet with counsel, or if you decide that you want to confer with counsel. Once again, if you want to schedule a consultation with us, we're scheduling half-hour consultations with our federal employees. And I think we've indicated before what the fee is for the consultation. I think it's $150. And but everyone has I won't say everyone, but most of you have different issues. And you may need to confer individually with counsel, particularly if you get some type of notice from your agency, or you have some questions about either the deferred compensation offer or whether the agency can actually take certain action against you. Now, before I get started here, uh, with your rights, many of our clients who are probationary employees received a notice, as I mentioned earlier, that they were being terminated because of their abilities, their skills, and their knowledge, and their performance was not satisfactory. So we're going to walk through what are your rights as a probationary employee, what are your rights as a career employee, or some other category, and what you should do if you get a notice. So the DEIA folks who were terminated, if you were a career employee, we're going to talk about that in a minute, what you should do if you're a career employee. If you are a probationary employee, we're going to talk about that as well. And then we're just going to talk about how this process works. Okay, so the requirements, and I'm just going to walk through this. Let's just start with probationary employees. So most probationary employees are hired and they work for a period of 1 year. Schedule A employees are hired and they're on a probationary period for 2 years. So if you're on a probationary period for 1 year, most folks get either some type of mid-year assessment of their performance or end-of-year assessment of their performance. And that basically confirms with the employee that they're meeting the expectations of their job. So many people have received a notice saying that you're not meeting the expectations of your position, which is false because they have something to confirm that. So I would encourage you, if you think you're gonna challenge this, make sure you gather all of your emails or any type of feedback that you've received from people you've worked with, or maybe even reach out to some of those people that you've worked with, because they may become witnesses in your case if it looks like your case has to be filed with the MSPB and there's no resolution of it. All right. So an agency has to provide a reason if it's going to terminate a probationary employee. It cannot terminate a probationary employee for false reason and provide false reasons. All right. And so an agency cannot mask a reduction in force as a termination. And that's what happened with the case that's pending at the MSPB. The Office of Special Counsel said that, look, even though these folks have been terminated as probationary employees, in effect, what you've done is implemented a reduction in force. You haven't followed the guidelines for reduction in force. And for that reason, we believe we're going to prevail against you in this case. And the MSPB essentially agreed and granted a stay. Now, the case still has to be litigated to its conclusion, but the fact that the MSPB granted a stay indicates that it's a strong likelihood that these employees will prevail. And that's true for the TRO. And when you talk about trying to get a temporary restraining order, it's an extraordinary writ. It's rare that you see a court issue a temporary restraining order because the person who files the complaint has to present enough evidence to convince the judge that there's a violation of the law and there's a substantial likelihood that I'm going to prevail on this case and I will suffer irreparable harm if this TRO is not granted, and the public in general will benefit from the TRO being granted. That's the same standard as for a stay at the MSPB. So these folks have had to present enough evidence to the MSPB for the MSPB to conclude that, or at least one member of the MSPB to conclude that there's a substantial likelihood that they're going to prevail on their case, that they have a strong case, that they're going to suffer irreparable harm in the absence of granting a stay. So that's already happened for employees who are probationary employees, or at least these 6 employees. And then the next point is the agency cannot terminate because of political reasons. I mentioned that earlier. That's been interpreted to mean partisan political reasons, meaning you have to say, I'm being terminated because I'm in the Libertarian Party or I'm in the Democratic Party, but rarely is that going to happen, as well as the agency can't terminate because of marital status. So if you are a probationary employee, and share this with folks who are probationary employees, and you've been terminated, and the agency, well, if you've been terminated in the last 60 days, not 60, last 5 weeks, with this administration, you should file a complaint with the Office of Special Counsel, or you should file an appeal with the MSPB. So if you've been terminated and you're a probationary employee, the MSPB has already found that this termination was problematic and it was likely a reduction in force, and the agencies didn't follow the reduction in force. They couldn't have followed the reduction in force because that requires a 60 days notice. So these people need to, if you're in that category of people, I talked to someone yesterday, some of you have um, termination notice is effective March 14th. You have to wait until the notice becomes effective, but you should immediately file an appeal with the MSPB or file a complaint with the Office of Special Counsel. There's a form that's called Form 14 with the Office of Special Counsel. We'll get to that in a minute. You just complete it, provide the information about who you are and your position and why you're challenging the termination. Our office can help you do that. If you want to engage our office, we're happy to help you do that and enter into an engagement agreement with you. So that's the probationary employees. And then the reduction in force. Here are the points on the reduction in force. One, the agency must provide 60 days notice to its employees. I mentioned to you earlier that we represented a group of employees at the VA, and we sent in a letter to challenge their termination. The employees were challenging or complaining about the termination not complying with the RIF guidelines. The agency finally decided that it would rescind the notice, even though these folks were terminated on February 14th. They got an email saying you are being terminated effective immediately. No notice at all, no severance, no option of placing them elsewhere. Well, the agency finally decided on Thursday to rescind this decision and re-employ these folks, and said it would keep them on paid administrative leave, but they're also going to go forward with a reduction in force. And they also sent out a notice saying, we're going to go forward with a reduction in force. And what is that going to look like? They're going to say your position is going to be eliminated within 60 days, or, well, they're going to say, here's 60 days notice that there's going to be a reduction in force. Then they have to follow whatever guidelines they're required to do for the reduction in force, create a retention register, and place people on the retention register and follow the process for terminating folks, and either offer to place them elsewhere if there are positions available, or give them priority placement if they're separated, or offer severance pay. So 60 days notice, create a retention register with a category of who would be impacted by the reduction in force, list employees on a retention register and note their performance. We see that these retention registers will often note the employee's performance. These are valid concerns. If you were doing a legitimate RIF, you would list the the performance evaluation of employees and their tenure at the agency. Then offer RIF employees reassignment or priority placement for vacant positions. Offer RIF employees severance based on years of service. All right, now I just mentioned this earlier, filing legal claims for probationary employees. And I mentioned if you're a probationary employee and you've been terminated, you can try to go through this process on your own, or you can get counsel involved. I know that there is a law firm, actually two law firms here in Washington, D.C., that are pursuing claims as class actions on behalf of the probationary employees. So you can consider joining one of the class actions as well, or you can get your own private counsel involved. But basically, if you're going to file with the Office of Special Counsel, you should complete Form 14, and the Office of Special Counsel, if it functions as it should, it should respond very shortly, within a matter of days, and advise you how it's going to proceed. The Office of Special Counsel is very efficient, so they will advise you how they're going to proceed. And if you're requesting that they file an appeal with the MSPB on your behalf, you want to be included with employees who are probationary employees and who are having their appeals filed at the MSPB, in light of the Office of Special Counsel's work, it's a very good chance that they will include you there. And here are the arguments that you're making, the same that the Special Office of Special Counsel's already made, that the agencies carried out a reduction in force without following the reduction in force regulations, and you're requesting a stay of the termination, reinstatement, back pay, and if you separately consulted with counsel or you've retained counsel, your attorney's fees as well. All right, so those are the protections for the probationary employees. So it's not hopeless. As a matter of fact, it's looking, at least for the probationary employees, you will get an opportunity to be reinstated. And then it's unfortunate, but they're probably still going to go forward with the reduction in force. It just means that you'll get the 60 days, which you'll probably remain on administrative leave, and then they'll have to carry out the reduction in force, which may take another 30 to 60 days. So if I'm guessing based on my experience, if you proceed and you're successful, you'll probably get your employment extended by 4 months. The better option, if it's between the 4 months and actually getting the deferred compensation offer, which is what I advise our clients who were probationary employees to seriously consider, that's, now I guess it's about 6 months since it expires September 30th of 2025. So maybe with some advocacy on your part, you can get them to offer you or extend the deferred compensation offer. But for folks who are probationary employees, it looks like there's a very likely possibility that your employment is probably going to end in the next 4 to 6 months, unless a court intervenes and says that the president just can't do this or the agency just can't do this. I haven't seen anything to suggest that the court is going to do that. And that's why I mentioned that DEI case in Northern Virginia, where the court basically said, I'm willing to allow you to take this deferred compensation offer. All right, let's scroll down to the next page. All right, so let's talk about permanent career employees. Now, this is a little different from probationary employees, and I'll just take a minute to explain this. As a permanent career employee, you have a property interest in your position. And you can't be deprived of your property interest or in your position without notice and an opportunity to be heard. And what that means is basically for federal employees, once you're a career employee, in most instances, you can only be terminated for either performance or terminated because of conduct. And we've seen this with some of our federal employees. And as I mentioned this before, if there's a performance issue or a conduct issue, or the third option is a legitimate reduction in force. So you're looking at these three options. Is there a performance issue, if there's a conduct issue, or if there's a valid reduction in force? And as I mentioned before, we represented a group of employees. These were all career employees who worked in DEIA. They didn't work in DEIA. They worked in a program, and it was confused by the agency as something related to DEIA. It was actually not a DEIA program. But anyway, they were targeted for removal. Their agency believed it was following the guidance from OPM and from the White House. So we'll see how their case pans out in the future. But anyway, I've just spent some time talking about a reduction in force, what the agency is required to do for reduction in force. The same is true for what it's required to do for probationary employees, it's required to do for career employees. If it's going to do a reduction in force, it needs to provide 60 days notice and follow the other procedures that I just outlined. So the agency can't say, for example, that we're going to terminate you based on your conduct and not provide due process. We're dealing with a case now where someone their agency is attempting to terminate them because of their affiliation with a DEIA program. And they're not going to be able to do that without providing due process. So as a result, in that particular case, the agency has to give my client notice that you're being charged with whatever, some type of misconduct, and set out the specifications and provide notice to my client and give us an opportunity to submit a written response and an oral response before the agency can take action against my client. So if the termination is based on performance, I'm just going to walk through this very quickly. Permanent career employees, they have a property interest in their position. Agency employees must be given notice of any performance or conduct issues and be given an opportunity to submit an oral and written response. There's a Supreme Court case called Loudermilk, which requires this notice and an opportunity to be heard. The agency cannot mask it as a reduction in force. So if you're a career employee and you get a notice that you're being terminated through a reduction in force and you're walked out the door that day, that's illegal, that's invalid. You can challenge that. So, and that's what's happening. That's why this MSPB decision is so important, because people were just being walked out the door and the agency saying, okay, we have the right to just terminate you just like you would private sector permanent employee. You just can't do that. All right, so the next point is the agency must provide notice to the employee and an opportunity to submit a written and oral response before that person is terminated. They don't have the option of terminating you and then saying, okay, come back and tell us why you should not be terminated. They have to do it before. The agency, if it's based on performance, the agency must show that the employee had poor performance before being placed on a performance improvement plan. Of course, none of that's happened in the last 5 weeks. And if there's a PIP, the employee is placed on a PIP and the performance continues to fail before they are terminated. So you really can't terminate someone based on performance without following this process. The leading case for this proposition is Santos v. NASA. So this case was issued in 2021. It was a major win for employees, federal employees. So you can't terminate someone for performance unless you place them on a performance improvement plan and their performance was deficient before they were placed on a performance improvement plan, and then it continued to be deficient, and then you terminated them. So if someone was assigned to work in a DIA office, that has nothing to do with being placed on a performance improvement plan. So you can't really terminate someone for their performance because they worked on a DIA office. The same is true for some of the other policy reasons why people are being terminated. We're working with a client now who was terminated because she was assigned to an office where they did cybersecurity and there was a review of interference by foreign governments in the election interference. And this person was terminated allegedly for performance because they were assigned to work in this particular office. That's illegal. You can't do that. You can't terminate someone without placing them on a PIP and they continue to show poor performance. So there are a lot of options available for challenging these actions, but for this particular client that I just mentioned, she's going to have to request to submit a written response and give the agency the authority, which shows that they are violating her rights, and also request an oral hearing where she basically presents her case to the hearing. In most instances, you're probably going to need counsel for that. If you're in that category, you can reach out to us or other counsel. All right, so that's the performance, termination based on performance for a career employee. Then there's termination based on conduct. It's usually when someone does something that violates the standard of conduct, whether it's, I don't know, sleeping on the job or getting into an argument with someone or, DUI or something like that. But conduct, if there's a conduct-based termination, the employee must be provided notice of the reason for the termination. The agency has an obligation to show that it had a policy in place that placed the employee on notice that their performance would lead to their termination. And once again, the agency has to consider what's the Douglas factors. These are 12 factors that the agency must use to evaluate the seriousness of the offense, how they've treated similar offenses in the past. This is just a few of them. Whether there's any chance of rehabilitation for the employee, whether there's any other penalty that could be considered other than removal. So you can't terminate someone because of conduct because they worked on a DEIA program or worked in some program that this administration does not favor. And so the agency can't provide a false reason. They're going to have to justify and prove that the employee engaged in the misconduct, as well as prove poor performance as well. And again, the agency cannot mask a reduction in force and based on conduct. You can't take action based on conduct through a reduction in force. Okay, so these are legal challenges that are available for career employees. One, you can file a complaint with the Office of Special Counsel alleging a prohibited personnel practice. Once again, that's Form 14. We can assist you with doing that if that's needed, or you can do that on your own if you believe you can. And most people can, it's not an issue. Or you can file with the MSPB to either challenge some of the points that we've raised tonight, to challenge a reduction in force, to challenge the falsity of the reasons for the termination based on performance or conduct, and to challenge the failure to provide due process. And the due process rights are based on the Fifth Amendment to the U.S. Constitution, which says that we have the right to life, liberty, and property, and we can't be deprived of our property without due process. And you can also challenge if it's done in a discriminatory or retaliatory manner. I mentioned earlier that we have a client who was hired on a Schedule A, hired as a Schedule A employee, and her supervisor had been retaliating against her for some time because of a mental health disability. And that employee is probably going to have a claim both of retaliation as well as just a violation of her due process rights. Okay, let's go to the next page. We're going to take about 5 more minutes here to finish up for tonight. We try to do these within an hour session. All right, so let's go to page 3. Okay, and here's the final point, possible legal challenges of the termination of non-career employees. There are different categories of employees. Most people fall within they're either probationary employees or they're career permanent employees. But there are other categories: conditional employees, accepted service employees, Schedule A, or trying to think of, AD, administratively determined employees. So if you have a claim and the MSPB does not have jurisdiction over your claim, for example, your accepted service employee, the MSPB does not have jurisdiction over accepted service employees, you have the right to pursue your claim. You can still pursue your claim, but you're going to have to pursue it in a federal district court. The federal district courts have made it clear. Actually, the Supreme Court issued a decision. The case's name is, I think it's Elgin, E-L-G-I-N. It basically says that if you are a career employee and you're challenging something that falls within the jurisdiction of the MSPB, a reduction in force or a suspension of more than 14 days, you must file your claim at the MSPB, even if you intend to raise claims that the agency is violating your constitutional rights. There are certain employees who don't fall within this category, and you have the right to file in federal court. The leading case in DC involves someone who was an attorney. She may have worked, I think, for one of the agencies within the Department of Justice. And she was terminated, and the agency made defamatory statements about her in the process of terminating her. And her claim proceeded to court, and the court resolved the case. I think eventually it was resolved in her favor. But basically, this is when your agency takes action to remove you and makes defamatory statements about you along the way or on your way out the door. So you can argue, one, that this violates your rights under the First Amendment if this violates your right to freedom of speech, something that you said, or maybe if you've been seen as associating with the associating with a policy or program that the agency has found that this current administration disfavors. The DEIA agents and or DEIA employees for the intelligence agencies in the case that was pending in the U.S. District Court in the Eastern District of Virginia, they made that argument that, we were terminated because there was a perception that a belief that we were working in a program that was disfavored by the administration. The court still ruled against them. So this is going to be probably jurisdiction dependent. So the way the court rules in the Northern District of Virginia is not necessarily how the court would rule on this issue in the District of Columbia. All right, Kaylin, can you put that back up, please? Okay. And then the next point is the Fifth Amendment to the U.S. Constitution. We have the right to life, liberty, and property. An agency may not make false reasons about you or give false reasons about you and terminating you without giving you a name-clearing hearing. And the agency may not deprive you of your property interests in your position without providing due process. So they can't defame you. That infringes upon your liberty interests and your good name and reputation. All right, and then the Fourth Amendment just says that you're entitled to equal protection under the law. So the agency can't treat you differently than it treats other employees. So we had a couple of questions. Kaylin, so let's try to go through a couple of questions and we're going to finish up for tonight. Well, I'm just going to speak quickly about two of the questions that I saw earlier. How does a government shutdown affect career workers, and will non-essential employees face a reduction in force after 22 days? I'm not sure what that means. Non-essential employees face a reduction in force after 22 days. Now, if there's a reduction in force and you've signed the deferred compensation offer, this means that you have to be treated the same as the other federal employees. And generally, when there's a reduction in force, generally when there is a government shutdown, there's a continuing resolution that needs to be resolved by March 14th, less than 12 days now, or we're going to have a government shutdown. If this is not resolved and there's a government shutdown, you have to be treated the same as the other employees. That means that if they are eventually awarded back pay, as they should, if there's a shutdown, you should be awarded back pay or payment for the period of time that you were supposed to be on administrative leave because you accepted this deferred compensation offer. Then there's a question about the fork in the road training. Let's see, not training, but Treasury and the SEC will honor the fork in the road, and what effect does the failure to provide 45 days notice have on this? All right, so the way this 45 days notice operates is under the Age Discrimination in Employment Act, there's a different statute, the Older Workers Benefits Protection Act, which basically says that if there is a exit incentive that's offered to employees, and it's done basically as a group incentive, the employees have the right to see who else is going to be impacted by this, by the reduction in force. And they have 45 days to consider. If you're over 40, you have 45 days to consider and 7 days to revoke. If you sign this agreement and the agency doesn't provide you 45 days, basically you can still sue the agency at a later point for the claims that you've waived here. Now, the way this works is it's not really clear, but I've seen in some courts, for example, if you were paid a certain amount, I've seen the agency make the argument that if you want to challenge this, you need to give back what you've already paid. But we have a client now who was not given the required notice when he was subjected to a reduction in force, and his claim is pending in court with the claims that he agreed to waive. He hasn't been required to return any of the money yet, but that's basically how it works. If they don't provide you correct waiver, that means that you can still pursue a claim against them after, well, at some later point if you decide to do that. But you still have to prove your case. And you'd have to convince the court that you were not provided the waiver that's required by the ADA, Older Workers Benefits Protection Act. Okay, Kaylin, let's take a couple of questions before we wrap up.
What is your retainer fee?
Oh, wow. Okay. So for the consultations, we are doing half-hour consultations, and that really determines the half-hour consultation is $150. Then it's a question of what needs to be done. Which category do you fall in? If you fall in this category of people who are probationary employees and you've received this notice and you're going to file your claim at the MSPB or the Office of Special Counsel, we are requiring people to just pay for 1 hour's time, and that's 3 hours, $300. If you need to go to the agency, if the agency has issued an order to terminate you and issue a letter to terminate you and is claiming that it's terminating you because of your performance or conduct and you're a career employee, and you have to get a hearing before the agency and submit an oral response, there are going to be additional fees involved. We can discuss that. But we try to keep the fees as low as possible. But basically, you would have to submit a written response to the agency as well as do an oral presentation, basically present your issues before a deciding official. And then depending on that outcome, you may have to still file an appeal at the MSPB if the final decision is still to remove you. So that's one option. We have clients in all of these different categories, even right now. If you are not a career employee and you are in the accepted service or administratively determined position and you're going to have to file a complaint in court, then there's a third option that we will need to consider, and that is usually combination of some number of hours. And then if we reach that number of hours, then we'll go into a contingency where we accept a percentage of the outcome in your case. But I'm happy to discuss those details with you through a consultation if you want to reach out to us. Okay. Kaylin.
If your position is abolished and there is no placement for you, can you retire with a VERA?
Yes, if you're eligible for VERA, that that should still be an option for you. And for those of you who think you're going to be, terminated, yes, that's definitely something that you should consider. Now, the question is whether you can do that if you've already received a termination notice and you have a specific date. You should be able to retire if you're eligible for early retirement. Any other questions? Just one more question and we're going to wrap up.
Can you touch on transfer employees?
Okay, so this is an interesting question. I assume you mean if you transferred into a position and you had to serve a probationary status in this new probationary period in this new position. I know that some agencies, they're doing this so quickly that they're just lumping those people into the category of probationary employees, but a lot of people are detailed into a new office or they transfer into a new office. The MSPB has come down generally, and of the cases I've seen, has come down in favor of employees where you're transferred to another position. I've seen cases where the MSPB said that this person was not required to serve a period of probation. Now, and for that reason, the agency could not terminate that person as a probationary employee. I will tell you that there are a lot of people who work in HR for federal agencies. They are accustomed to doing their jobs a particular way, And as long as that satisfies whatever the requirement imposed upon them by their supervisor, they will continue to do that job, but their job that way. But many times it's not the correct way. It just hasn't been challenged. So someone will have to challenge it to make sure that it aligns with how the OPM uh, rules in similar cases. So you can't just accept the agency's HR person, the fact that they process your transfer as a probationary employee, particularly, and we've had this recently where people basically doing the same job and move into positions. Some people are required to serve probationary periods, others are not. Others are basically said, your permanent career status transfers with you and you're not required to serve a period of probation, and therefore I should not be caught up in this reduction in force, at least right now, or this termination from employment as a probationary employee. Okay, so that's it for this evening. We will see how things develop. I know that on March 14th, some of you are going to be terminated on March 14th, and you're going to have to look at whether you're going to file an appeal with the MSPB at that time. I think there are other deadlines being floated by the OPM as far as agencies getting back to them with their specific plans for reduction in force around the same time frame. I think we'll likely wait until we get some further guidance from OPM and start to see some of the responses from agencies on these plans to impose these widespread reductions in force, and we'll come back on and have another webinar. All right, I think that's it for this evening. I hope this has been helpful for everyone. You can always reach out to me or reach out to Kaylin if you have follow-up questions or if you want to schedule a consultation. I'll be happy to speak to you. All right, everyone, have a good evening. Thank you, my sign language interpreters as well. You guys were fabulous.